All rise. Veuillez vous lever. Veuillez vous asseoir.
We would shortly come back to what has been said before the break, and we appreciated that Ms. Dimitri was very specific in her submissions. And this also means, since she was so specific, that the addressee of the specifics was the prosecution, of course. And as I said, and I reiterate that, the Chamber would appreciate it if these matters, since they are at least presented in such detail, should be resolved inter partes as quick as possible. The next issue on the agenda is the anticipated evidence, and we start with the estimated number of witnesses. The Chamber recalls that according to the recent filing by the prosecution intends to call 152 witnesses, excluding expert witnesses, 90 concerning Mr. Ngaissona, 62 concerning Mr. Yekatom. And amongst these, 109 witnesses are envisaged to give a live testimony, and 33 witnesses Rule 68(2)(b). The prosecution further submits that it has eliminated 53 incriminating witnesses. We have heard about that before today. It previously relied upon during the confirmation of charges proceedings, and this in light of the reduced scope of charges. The Chamber also notes the Ngaissona defense's observations on this matter, Mr. Knups. We have a few preliminary remarks before we give you the floor, Mr. van der Poel. First, the Chamber finds the number of witnesses to be rather high. Should the list therefore stay as it is, the Chamber reserves its right to limit the number of witnesses or impose a maximum amount of hours available to the prosecution to present its case, if the Chamber thinks this is required to ensure the efficiency of the proceedings and the accused's right to be tried without undue delay. Second, the Chamber finds the separation between witnesses for Mr. Ngaissona and for Mr. Yekatom a little bit unusual in light of the joint nature of the case, as this seems to suggest that there is no overlap in the evidence. Perhaps there might be more overlap than at the moment we think of. Consequently, we would like to reserve further submissions from you, Mr. van der Poel, on the following matters. Whether the prosecution expects the provisional and final witness list to be more limited. Secondly, whether there are overlaps in the evidence between the two accused which could perhaps lead to further limitations. And thirdly, we would like to hear how many witnesses are expected to testify at the seat of the court or via audio-video link. Of course, presumably this will depend on how the present situation evolves. The Chamber would be grateful for some first estimates. Mr. van der Poel, please, you have the floor.
Thank you, Mr. President. I appreciate your observation and attention to our previous filing concerning the number of witnesses that we have in this case. Yes, it indeed is the case that the prosecution has removed some 53 witnesses on the heels of the confirmation decision, which declined to confirm charges against Mr. Ngaissona for a number of crimes committed by the anti-Balaka in the provinces in Western CAR. But I think it's also important to remember that the confirmation decision effectively shifted the focus of the crimes as were alleged in the DCC to a period preceding the 5 December attack, much more so than the prosecution had presented it in its DCC. The DCC focused on crimes that were committed after Ngaissona became the national coordinator for the anti-Balaka on 14 January 2014. The confirmation decision effectively shifted the focus of Mr. Ngaissona's responsibility to crimes which occurred preceding the 5th of December attack in 2013. And so,
Yeah. I've also been already admonished, Mr. Van der Pooijen,
It's not just me.
for speaking. No, no, it's not just you. Let me put it this way. In this, at least, you're not alone.
thank you very much, Mr. President. I appreciate that vote of solidarity. So the confirmation decision effectively shifted the focus of Mr. Ngaissona's criminal responsibility or liability to a period which preceded the 5th December attack, and then attached also liability to the crimes of Mr. Yekatom, which followed it. That has the effect of changing the focus of prosecution witnesses from the period following his designation as the leader of the group to the period of time preceding it. And that is what the shift is that is identified by Yekatom's defense counsel as dropping 53 witnesses and adding other witnesses, which we already had. So that explains the scope of or the number of witnesses, and indeed, there are experts that we intend to call as well. Okay.
I don't want to interrupt you, but simply to flag it, we're coming to expert witnesses or
okay.
or experts, as we would say in Germany, not witnesses,
Yes.
but we come to that later.
All right. So we have a number of experts that we intend to call as well. And indeed, you're correct in your observation. There is an overlap in the number of witnesses, but that's actually accounted for. We wanted to sort of give the chamber an idea of roughly how we're viewing the evidence or the relevance of the evidence with respect to each accused. As you will recall from the confirmation decision, Mr. Yekatom is much more hands-on in relation to the crimes with which he's charged than Mr. Ngaissona is. Mr. Yekatom is charged as a principal in the commission of those crimes. Mr. Ngaissona is charged as an accessory. And so the number of witnesses that relate to Mr. Yekatom's involvement in the commission of the crimes is fundamentally different because the nature of his involvement is also different than Mr. Ngaissona. So we wanted to give you an idea of how that splits. There is undoubtedly an overlap because they're both members of the same group, because they're in contact with one another, because members of their circle are together, and all of those kinds of things. And the crimes form part of a wider pattern of crimes that are committed by the group in general. So there is clearly a fair amount of overlap, but that is accounted for in what we've done. So in terms of the numbers of witnesses, okay, I think we have identified around, if you just bear with me 1 second, I'm sorry. The majority of witnesses, I think we had hoped to call live. Obviously, that is going to be subject to logistical constraints, not the least of which is, of course, the ongoing pandemic. We'd identified about 33 witnesses that we could call through audiovisual link. Many more we would hope to call live, and particularly insider witnesses, of which we have quite a substantial number. So, I don't know if I have the total here. But in any event, it's roughly that. We also intended to call 48 witnesses through Rule 68-2. And to that extent, we think that would be appropriate here, where we have witnesses that aren't talking necessarily about the acts and conduct of the accused, but perhaps the acts and conduct of the group, the acts and conduct of the subordinates of the accused, contextual elements, crime base, or victim-centric evidence as well. So we think that there's a fair number we can cover that way as well. So, yeah, then we're looking at about, I think about 70 some odd witnesses to call fully live if we can get them here. But like I said, that number is likely going to change.
And the question of audio-video link?
Audio-visual link, I think around 33 or 34 or something like this, we anticipate we could call.
Thank you very much. Any comments by the defense to that? But please no repetition because there have been some submissions already, and as you have heard in my introduction to this issue, we are aware of that. Please no repetition, but of course, Mr. Knops, you can cover it if you want.
Thank you, Mr. President. Of course, we will only respond to the prosecution submissions in this regard. For this subject, I have speaking notes for the booth. It starts at page 13 for the translation. I will first address the impact of the reduced scope of the charges, not in detail, of course, like you said, but I will just briefly touch upon several items, 3 items. Mr. President, we asked the Chamber, indeed, to proprio mutuo reduce the list of witnesses, at least the number, in light of the clear decision of the pre-trial chamber, where the geographical and temporal scope, as well as the contextual elements, were clearly defined. 4 locations are left to be litigated in less than 3 months of time span. I remind the chamber, pardon, probably needless, that the prosecution did not seek leave to appeal the confirmation of charges decision, which means that they accepted the scope of the ruling, was set by the ruling, and therefore also the contextual elements of the alleged charge. The question whether, once the pre-trial chamber declines to confirm certain charges, these charges can indirectly be relied upon to prove contextual elements of the charged crimes in a particular context, should be answered in our submission with no. Particularly once the pre-trial chamber, like in this situation, refrained from making any factual findings with respect to these non-confirmed incidents. I remind the chamber that in paragraph 23 till 25 of the pre-trial decision, pre-trial chamber's decision on the amendment of the charges of 14 May, the pre-trial chamber also answered this question in the negative. The prosecution cannot reintroduce non-confirmed charges for which the evidence was lacking. Now, the prosecution has cited 3 precedents of the ICTY jurisprudence and 1 decision of the ICC, Nataganda, in its submission of the 20th April in footnote 10. The 3 ICTY cases of 2002, 7, and 9, nor the Nataganda decision can assist the chamber in this regard, because they all dealt with charged crimes. Charged crimes as part of a widespread or systematic attack. The present debate, Mr. President Jonas, features about non-charged crimes and not about charged crimes, which the prosecution tries to introduce to stipulate its alleged contextual elements. The pre-trial chamber clearly, in our situation, refrained, contrary to the Nataganda decision, the confirmation decision Nataganda, clearly distinguished from that decision that the pre-trial chamber, in the case of Mr. Ngaissona, refrained from entering into any factual findings about the non-confirmed charges. And if you look also into the separate opinion of Judge Stafusser in the Abu Garda decision, he is taking the same approach, and that approach is also referred upon by the pretrial chamber in our case. If the evidence is missing, it is not necessary to go into the legal analysis of the potential contextual elements. Now, second point, so therefore, to summarize the point, Mr. President, the prosecution can no longer, post-confirmation, rely on elements that are outside the facts and circumstances of the charges to prove potential contextual elements. The same applies for the argument of the organizational policy.
May I just interrupt you here?
Yes.
We have taken note of your submissions in that regard, and as I said initially, we are limited in time today, and please don't repeat the arguments that are in this. So I would ask you to shorten this.
Right. The same for the organizational policy argument. The same system applies, and the allegation of the prosecutor that it would like to use the prior intent argument. In addition to our submission, Mr. President, we would like to emphasize that there is no authority in support of the proposition of the prosecution that circumstantial evidence of an accused prior intent through subsequent acts of or post-offense conduct would be well recognized and even commonplace in criminal proceedings. One remark, of course, we all know that in the United States federal rules of evidence, this is allowed, but the problem here is we are dealing, contrary to this precedent in other proceedings, with a pretrial chamber, a confirmation of charges decision, which makes it distinct from other jurisdictions whereby a potential prior intent can be deduced from subsequent acts. So the prosecution ignores, in this regard, the clear distinction between those jurisdictions and ignores the findings of the pretrial chamber that the evidence did not show Mr. Ngaissona's alleged uninterrupted involvement into the anti-Balaka activities, and that he had limited, if any, knowledge and control over their actions. So the prosecution simply submits a partial reading of the confirmation decision, omits to mention these clear findings of the chamber. Therefore, Mr. President, we ask the chamber to considerably reduce the number of witnesses in line with the decision on the confirmation of charges. We also ask the chamber to reduce the number of the so-called international witnesses. You find on the list several individuals, mainly journalists and people from NGOs. These have not been removed from the list, the preliminary list, by the way. Yet, if you look at those statements of those individuals, these people were not personally witness of any of the alleged crimes, and they limit themselves to the collection of anonymous information in the aftermath of the events. A large portion of these statements, therefore, are not relevant or cannot have any probative value, which was also established in the Bakbo Blegoudé case, where the chamber specifically ruled on those international witnesses. So the list can also be reduced with those individuals. And finally, Mr. President, speaking about a parallel investigation of the prosecution into the Seleka, instead of putting on the list international witnesses who cannot personally testify about any event, the prosecution did not include I'm not mentioning them. Several witnesses who could testify about the events, also from the perspective of the Celica coalition. I will not mention them in open session. If the court wishes, I can go into specifics with the numbers.
No, we understand that.
Thank you.
We can stay in open session.
And there is also one important witness, that's P0958. The other person I referred to was P1019. That witness specifically could give a real account of the history of the conflict, the role of the DDR process, and the role of Mr. Ngaissona. So we asked the chamber to reduce the witness list of the prosecution, including a review of the so-called international witnesses, and also look into the two witnesses I just mentioned, because if we're speaking about an account of the history of the conflict, instead of relying on journalists, we suggest that the mentioned witnesses are far better, giving best evidence to this situation. Thank you.
Thank you, Mr. Very
Want
much.
you want me to respond also to the protective measures directly, or?
Not at the moment.
Okay.
I think we come
Thank
later,
you.
we come later to that. Ms. Dimitri, do you want to add something?
Thank you, Mr. President. No, we stand by our submissions, I think, in filing 472 regarding video links and the use of Rule 68.
Thank you very much. Mr. Van der Poeje, first of all, shortly, you have not really answered my first question. If there is potential, if you see potential to limit your provisional and final witness list. Listening to Mr. Knops, at least, of course, there could perhaps be potential, so to speak. With international witnesses, you have no direct knowledge of any events that are part of the confirmed charges.
Yes, there's kind of two answers to that. One is some international witnesses do actually have direct evidence of events that they've witnessed. And for example, if some witness shows up in Bosangoa on the 7th of December 2013, as opposed to the 5th of December 2013 when the attack happens, and they find a Muslim village in flames and smoldering, that is relevant evidence of an attack.
Mr. Van der Poeje, I think I can shorten that. Of course,
Right.
These witnesses have might have some sort of knowledge, of course, but I understood Mr. Knops more in a way that is so-called international witnesses, and I know, of course, also the Gbagbo Blegude case, who are completely restricted to hearsay, so to speak.
Sure. We have considered that, and as I mentioned before, where witnesses have evidence that doesn't go to the acts or conduct of the accused, it's not our intention to call them to come and testify. It's our intention to tender them pursuant to Rule 68 because they have evidence that doesn't go to the acts or conduct of the accused and which will facilitate the expeditious conduct of the proceedings. Rather, it's the defense, Mr. Knops in particular, who objected to the prosecution's use of Rule 68-2 in exactly this manner in relation to our prior submissions. I would also add, in terms of the scope of the case, a couple of things that I think are responsive to Mr. Knops's points. The first is, in his reference to the Ntaganda decision, I think it's as clear as day. It says, as the charged crimes must take place within the context of an attack, the prosecutor is free to present further additional acts to the ones charged with a view towards demonstrating that attack. In the context of this case, that attack was framed by the pretrial chamber, who wants to talk about facts and circumstances, as follows. As a result, from September 2013 onwards, the Muslim population became the target of deliberate attacks carried out by anti-Balaka groups as a form of retributive violence throughout Bangui, Boeing, Bimbo, across Western Kar prefectures, including Bosangoa, Berberati, Karno, Gwen, Boda, Bosimtele, Yaloke, Gaga, Zawa, and Bwali. We charged all but Bwali in the original DCC. The fact that the trial chamber did not find Mr. Ngaissona individually criminally responsible for those crimes does not mean that those crimes don't form part of the attack. So in terms of the scope of the case and the scope of the confirmation decision, I think it is pretty clear what the pretrial chamber confirmed, both in terms of temporal nature of it, its geographic nature, and the number of victims as well. The same goes for the findings concerning the contextual elements for war crimes. As you'll recall, Mr. Yekatom is charged with a war crime in the use and recruitment of children, which, according to the pretrial chamber, occurred at least through August 2014. So that, and the fact that there was an armed conflict which preceded that or continued during that period, is a relevant contextual element and is further demonstrated by the fact that there were attacks in all of the places I just mentioned. So I think there's no question about what the scope of the evidence is as a result of or following the confirmation decision. More particularly in the operative part of the confirmation decision, the pretrial chamber says explicitly that the crimes occurred all committed as part of a widespread attack carried out by the all committed, listing all of the crimes, as part of a widespread attack carried out by the Anti-Balaka, including Yekatom's group, between September 2013 and December 2014.
So I have to interrupt here because this goes a wrong path, so to speak. Not that I say that anybody, what has been said is wrong, but this is status conference, and the chamber will address at the end the scope of the charges and motions that we have received in that regard. So we don't discuss this here. This is not the time for it. And of course, the chamber is also fully capable of understanding what the scope of the charges means, how far it extends, and what this for the taking of the evidence then means. So you can really trust us that we know the jurisprudence and that we perfectly know how to handle this. So I think we can stop this here and go over to the next point.
That's fine. I was just responding to Mr.
Yeah, I did not
Mr.
interrupt you earlier because I gave also Mr. Knops the floor for that. So, but please understand both that we have to limit that here. So we could discuss this for 5 hours ongoing here if we want to, but we don't want to and we don't have the time to. Expert witnesses. The chamber notes that the prosecution recently indicated that it intends to call 5 experts on different topics: historical and overview regarding the conflict, satellite photography, trauma, call data records, child soldiers. The chamber also recalls that the Yekatom defense proposed joint instruction of experts. At the same time, the chamber just recently received notification that the Yekatom defense is interviewing an expert on the car. I'm not saying now whom, but that you are at the moment in the process of doing that. In light of the potential topical overlaps and also noting the experience with expert witnesses at the court, the chamber is interested in streamlining the presentation of expert evidence and would very much appreciate cooperation between the parties. The chamber would be particularly interested in hearing from the parties whether they can envisage joint experts, not joint instruction, joint experts on certain more neutral, not evidence-related topics. So you know probably that all judges here have been in other cases already, and sometimes it really seems that the parties in fact agree, or at least should agree, that some of the experts are simply experts in their field and they are not to be related to the prosecution or to the defense or whomever. This would mean that the parties agree on an expert but may both ask questions. Yeah? We are not talking about the joint instruction, as I said, but which, insofar the experiences at this court are not very promising, and it would make perhaps the whole process too complicated. But to agree on joint experts. I will give you an example, so not to stay in the abstract here. The just mentioned expert, Yekatom defense, could testify about a rather undisputed matter between the parties, namely the historical conflict in the car. And it seems, at least, that this expert is accepted by the Yekatom defense and the prosecution, and probably also by the Ngaissona defense, and thus appears to be a suitable candidate for such a joint expert. But this is just an example. This should not be misunderstood as to be limited to just this expert and to this particular area of expertise. Of course, we are also aware that there are limits, of course. There are topics which have to be contested by the other party. I know that the Chamber knows that. But we would appreciate your view on what I have said, on the potential to agree on joint experts, and for which topics. So, I again start with the prosecution. You're always the first to give your views, Mr. van der Poel.
Thank you, Mr. President. I appreciate that. Yes, on the issue of the joint instruction or joint agreement as to certain experts, I think it's important to mention from our perspective that, we've been gearing up for this case for a very long time, and there are a number of expert witnesses we already instructed ahead of the confirmation process. And those would consist of experts in child soldiers, trauma, satellite imagery, demographics, and I believe we have one on CDR. There was one remaining by the time the case had been confirmed, which we had not yet instructed, or were in the process of thinking about instructing. And we approached the defense on an overview witness who could testify about the situation and the historical context in which the crimes occurred, or at least the conflict occurred, who the various actors were on the ground, that kind of stuff. But we did not get consent from the defense with respect to this.
But perhaps it would make a difference if there is a sort of a mild inducement by the Chamber. I think we give it simply a try. If you don't agree, perhaps the Chamber will have to reserve its right to name their own experts, so to speak.
We're happy.
But we are always. But this is the principle of this Chamber, and has been with other chambers where I've been sitting in, that we appreciate, at least in matters which are not contested or should reasonably not be contested, cooperation between the parties. I've mentioned this several times.
We're very happy to collaborate with the defense to this end. But what I'm saying to the Chamber is that we have made that overture, and in light of the fact that the defense did not wish to agree to the particular person we had in mind, nor counter-propose anyone else, we've gone ahead and instructed that person, and they're actually working on the report, and so on. And we have that in a number of circumstances, because we didn't have the joint instruction or an impetus to have a joint instruction of witnesses in the lead up to the confirmation process at all with the defense. So we're almost done with the instruction of the witnesses that we intended to call as experts. But I'm happy to consider whoever else they might propose.
I will make a proposal in the end. What the Chamber could think of proposal, meaning that you make joint submissions and you confer with each other. But let me first hear by the defense what their opinion is on that matter. Perhaps you reject it completely. So this, Ms. Masida later. Ms. Dimitri first.
Thank you, Mr. President, Your Honors. Indeed, we will. We welcome cooperation with the prosecution. We did it on a number of occasions on different matters. And our position is the following. Maybe we can take it a step backwards. First, we need to identify the subject matter that could be a subject of expertise. And I can think of subjects such as CDRs or satellite imagery. And then, of course, if the prosecution agree, we can discuss and we can discuss the name of an expert. There are some subjects, and this is the expert the prosecution is referring to, where we do not feel the need to have expert witnesses testifying, because prosecution has on their list several witnesses who can speak about the conflict or the background or the context, and this is our position. But we will endeavor to further communicate with the prosecution on that point, Mr. President.
Thank you very much for that. I would agree with you, and of course, this is the last what you mentioned is another issue. Of course, if you say principally this is not an issue that is expertise witness, but simply witness that can convey us with this information. And I have to say also from the ongoing case, our experience is that sometimes the classical witnesses, which are not called formally experts, provided better evidence, so to speak, or good evidence on matters that so-called experts who, for example, come from the West, from some European country and have made some sort of academic findings, but in the end, the people on the ground, the people that live there, that are socialized there, that come from this culture, might know better. Yeah. But nevertheless, so Mr. Knops, you want to say?
Yes, Mr. President, that is exactly also our position, the last remark you made. My submission is that our defense team, it's not about not willing to cooperate. Let me stress this. We are, of course, willing to cooperate, but we, and speaking on behalf of the defendant, I spoke at length with Mr. Ngaissona about this issue. He prefers not to engage with experts, but to engage with witnesses who were on the ground. Like the two people I just mentioned, which are not on the list, P01919 and P958. My experience in other cases in this court and other tribunals is that most experts rely on secondary sources, hearsay, anonymous. What we will get here is a whole discussion about the sources of the experts who were not there. In my submission, and based also on experience with the other case of Bakbo Blekoude, we spent countless hours in court to question the witness, the expert in question, about, well, what is actually your foundation of this finding? You were not there. To whom did you speak to? To avoid this, it's my submission that, first of all, joint instructions, I would say, in my profession, that can go against the independence of counsel. I have no instructions of my client to allow me to give joint instructions to an expert with the prosecution. That's first of all. It has to do also with the ethical obligation of a lawyer. Secondly, when we're dealing with the reconstruction of the historical events, there is far better evidence in the file which is not on the prosecution list. And I asked the chamber to look into those witness statements I just mentioned, because if we're speaking about reconstruction of the events and the role of Mr. Ngaissona, for instance, that evidence is best evidence, in a way.
Yeah, of course, this is clear. But nevertheless, this is a little bit discouraging, so to speak. But you might have noted that initially I already said that we are not speaking of joint instruction.
No.
Yeah.
To finalize, Mr. President, I'm sorry that it's disencouraging. I'm not here to discourage this trial at all, but I'm just saying that for certain experts, like DNA experts or pathologists, that's of course different than from a witness or an expert who is post factum writing a report about the origin of a conflict. I think we have to differentiate between the type of expertise which we require. We are willing to look into this, but I will say beforehand, to be transparent to you and the prosecution, that the defendant I represent clearly says, I've seen the list of the prosecution, I've seen the list of international witnesses, I've seen the list of experts. This will not help in the reconstruction of what exactly, in my perception, happened. He's read the evidence. We read the evidence. And that's why I say beforehand, it's better to spend the time in court with some witness of fact than bringing here 5 or 8 experts and spending hours on verifying the sources. Thank you.
I think we are not speaking of 5 to 8 experts on these topics. I will be the
Of course,
chamber would
but
not-
just by way of example.
Yeah. So, but at least you said there are areas, and of nothing else. Is what the chamber suggests, that you entertain or the idea to have joint expert on certain fields, and it depends on the field, of course. But I would still maintain, Ms. Dimitri, this expert you were contacting might be one that everyone could agree upon, but we will see. Ms. Masida wanted to say something.
Thank you very much, Your Honor. I was surprisingly quiet today. Very, very briefly, for the joint expert, we will be happy to join in any effort for this kind of exercise. We are a little bit reluctant in relation to joint instructions, as already indicated by other parties, because we may have a different strategy of a different perspective in relation, for instance, to the victimization. But we will be more than willing to look into that, particularly, Your Honor, in relation to the trauma expert, which is one of our main issue for this trial. And also in considering eventually how the issue of victimization could be touched upon by expert proposed by the prosecution, so that there will be maybe a less interest on our part to eventually also call other witnesses to that effect.
Thank you very much. Thank you very much, Ms. Masida. So to finish that, should an agreement on joint experts be reached, which the chamber very much hopes, but is not sure if it can expect it after the conversation here, the chamber would appreciate to receive joint submissions with concrete proposals as soon as possible, and latest by the deadline of the final witness list, which makes sense, I think, for which the chamber will set a deadline in due course, as I have already mentioned. Lastly, the chamber would like to notify the parties and participants that if no joint expert can be found, it depends, of course, on the area of expertise, I have to underscore that, the chamber reserves its right to appoint its own expert. A little bit related to that is, Mr. van der Poeje, that we have, of course, also in light of the difficulties that you might have to call witnesses in the first place in the near future, so to speak, if you are prepared to adjust your presentation of evidence in a regard, for example, that you would first call experts or witnesses that are easily reachable because, or experts that they are in the Netherlands or so. So I think you should be prepared to do that. Perhaps you can simply say yes to what I'm supposing. So
Yes.
the next point is agreed facts under Rule 69 of the rule. Yeah. You have the floor.
Oui, Monsieur le Président, sur cette dernière question, je voudrais simplement faire une observation qui est la suivante. Si un projet d'accord est sur le point d'aboutir ou d'intervenir, nous ne nous immisçons pas dans le contenu de cet accord, mais il serait opportun pour les représentants légaux des victimes que ce projet, non pas le projet, mais que cette intention leur soit notifiée pour qu'elles puissent éventuellement donner leur avis ou faire des observations, indépendamment du contenu. Voilà, préalablement, on prenne soin d'indiquer au RLV que sur ce thème-là ou sur ce point-là, une proposition d'accord entre défense et accusation a lieu. Voilà, simplement nous notifier l'information.
Yeah, thank you. That is duly noted. The next point on the agenda are agreed facts under Rule 69 of the rules. So, the Chamber considers that agreed facts under Rule 69 of the rules constitute an important tool to ensure the efficiency of the proceedings. So this is for a Sunday speech, so to say. Unfortunately, in this court, this tool has been underutilized in the past. The Chamber would nevertheless welcomes that the parties have at least claimed to have begun discussions in this regard. We would particularly encourage you to concentrate your efforts on what are the disputed issues and allegations against the accused in this case. This would help in the end everyone meaning every party and participant. When deciding if it considered agreed facts as being proven, the Chamber will take into account the views of the representatives of the victims, if appropriate, in accordance with Rule 69. Irrespective of the outcome of Rule 69 negotiations, the Chamber also strongly encourages the parties to concentrate their presentation of evidence on the relevant and really material disputed matters. There is a wide potential, at least in my experience, of facts and circumstances that you might not agree upon, but which are in fact not really materially disputed. Doesn't make sense to spend a lot of court time on that. And this is, for me at least, after a couple of years here in the courtroom, a lesson learned, that there is much more potential in that regard. Even if you say, okay, we can't go so far to agree on it, but really we should concentrate. And the Chamber actually, this is also a lesson learned, will be vigilant that this actually also happens. Yeah. Now, in the light of the fact that 3 months have passed since the Chamber last received any information, we would like to hear if progress has been made or if not. Again, Mr. van der Poeje, please.
Thank you, Mr. President. I will say that I do agree with your assessment of the potential use of agreed facts as a tool to expedite the proceedings, particularly at the court. We did make a couple of overtures to the defense. We proposed in one set some 58 potential agreed facts, and we followed that with a second attempt of 106 proposed agreed facts. And maybe Mr. Knops can help me out here, but I think the Ngaissona defense basically agreed to 3 of those so far. They haven't responded yet on the one with 106 proposals, but they have responded to the one with 58 and agreed to 3 items. One relating to the date that Mr. Ngaissona was elected to the Federation of Football, Central African Football Federation. The second in relation to his representation of the town of Nana Bokassa in 2011. And the third relates to his nomination as the Minister of Youth and Sports and Culture by a 3rd February 2013 decree. That is essentially what they've agreed to. What was proposed concerned, obviously, more important, I think, information concerning...
but we can't be so specific now. This would take too long.
No. I'm not going to go through the facts, but the categories we're talking about are the contextual elements of the crimes, for example, the fact of Seleka crimes, the composition of the anti-Balaka, things like that, the numbers of elements, things like this. And the second proposal, much the same, more germane or at least arising directly from the findings of fact that were made in the confirmation decision. We'll wait to see what the defense response is with respect to those, but that's effectively where we are. The Yekatom defense has effectively, in my view anyway, declined to consider agreed facts. They had certain objections to the course of disclosure and have said basically we're not going to consider the agreed facts until you resolve the questions of disclosure, which to me seem to me disjointed, but in any event, that's their position, and I assume it remains the same. So it doesn't seem likely that we'll gain any traction in that respect either.
Yeah, so this accords perfectly with my experience in this court until now with different cases, but you never stop to try, at least. Mr. Knops, do you want to say something on that matter?
Yes, Mr. President. Yes, Mr. President, I think with your experience as a judge at this court that the expectations on this issue should not be to set too high. We're always willing to look at agreed facts, but if we are so fundamentally already disagreeing about the interpretation of the decision on the confirmation of charges, like paragraph 170, where the court specifically says no evidence between Mr. Ngaissona and the National Coordinator Bangui on the one hand, and the com zones in the districts, 10 of which were not confirmed. If the prosecution defense already, like today, when we speak about the scope of the charges, are so fundamentally disagreeing about the reading of that decision, it's difficult.
No,
Like
we
this-
can simply, I think, shorten this here.
Yeah.
Because
So-
I only wanted to have an update. Any specifics we cannot discuss here, and of course nobody can be forced to agree on anything here. So I simply wanted to have an update and the main information we have gotten from Mr. van der Poel in that regard. I don't know if there is still a potential, but you can say something that shortly.
Yes.
Something to that effect shortly.
We
but,
always, and that I can assure the chamber, we always, as defense, I did it in every case, despite this discrepancy between the readings of the prosecution defense on certain things, we always seriously look at the proposals. We take it seriously. And if we can, we certainly will agree to certain facts. But I just also here want to lower the expectation in this case where defense and prosecution so fundamentally disagree.
Thank you, Mr. Knops. Actually, you don't have to lower my expectations here, Mr. Dimitri.
Thank you, Mr. President, Your Honors. I just want to clarify the record here. The defense of Mr. Yekatom didn't decline to consider the agreed facts. We had a number of pending disclosure requests dating back to December 2019. We told the prosecution, respond to our letters, clear the docket, and then we will move forward and consider the agreed facts. We received the answer yesterday. We are now looking into the agreed facts and we will consider them. Thank you.
Thank you, Ms. Dimitri. So if the parties agree on anything, then we expect that they file a joint submission of such agreed facts, and we will set a deadline in due course, which accords to the other deadlines that we are going to set. So the last point on the agenda that you have received is the update and forecast on additional victim participation applications. At the moment, the procedure adopted by the pretrial chamber regarding the victim's application remains in place. We note two issues here. First, with respect to the first already accepted victim applications, the chamber notes that the factual scope of the charges has been reduced following the confirmation of charges decision, which may affect a number of accepted victim applications. Secondly, with respect to accepting further applications, the chamber takes note of the CLRVs and registry VPRS submissions that large number of victims might come forward, and the various challenges faced in collecting the applications, again, particularly in light of the coronavirus pandemic. The chamber would accordingly be assisted in receiving updated information now, especially from the CLRE and the VPRS registry, with respect to determining the number of participating victims in light of the reduced scope of the charges, and secondly, progress and forecast on collecting further victim applications. Ms. Masia, do you want to start?
Thank you very much, Your Honor. Now, in relation to the fact that the scope of the charges have been reduced, fortunately, this doesn't mean that the numbers of victims will be lower than expected. because some of our clients, for instance, waited until the confirmation or not confirmation of the charges to come forward. So this means actually that we have quite a large number of victims residing in Bangui and outside Bangui. So we have, for instance, a huge diaspora in Chad and Cameroon directly related to the events which were confirmed by the pre-trial chamber. As of today, we are managing of continuing our work in the field, which means that we are able, to some extent, to either collect supplementary information for the victims who may request the kind of information to qualify or to continue to qualify in the case, but we are also able to continue to collect new applications. The result of the work is that as of today, concerning specifically the clients who appointed myself, we have already provided to the VPRS 74 new application forms. We have around 250 in the pipeline and more applications arriving, just to give a short overview of the numbers. My colleague, Elisabeth Rabe-Sandatana, will be able to illustrate a little bit better the situation for Chad, and I will also tell you that for Cameroon, we have a huge numbers of victims dispersed there. We are talking of a little bit more than 3,000 people who could potentially be victims qualifying for this case. We have in place precautions to continue the work. So we will be able to continue to submit to the registry on a rotating basis application forms. However, and this is my last point, we would be more than grateful to the Chamber if the Chamber could consider to allow the legal representative of victims to continue on a rotating basis to file application with the registry at least until the end of a prosecution case. Thank you very much, Your Honor.
Duly noted.
Thank you.
Do you want to add something? You have the floor.
Oui, alors, merci, Monsieur le Président. En ce qui concerne la situation des victimes au Tchad, sur les victimes participantes acceptées, il n'y a aucune, à ce jour, il n'y aura pas de réduction du nombre de victimes parce que les premiers dossiers proviennent en fait du camp le plus proche de la capitale N'Djamena. Donc la plupart, enfin ce sont toutes des victimes originaires de Bangui. Ce qui fait que, en ce qui concerne le champ géographique, il est assez limité sur ce camp-là. La difficulté que nous rencontrons concerne les victimes qui vivent dans des camps le long de la frontière entre le Tchad et la Centrafrique. Là, il y a un nombre de camps importants, il y en a 7. Et également parce que aussi ces victimes-là sont passées par le Cameroun avant d'arriver au Tchad. Et là, les liaisons, notamment les liaisons par Internet, sont très compliquées. Donc, mais nous avons déjà 170 nouveaux dossiers, enfin nouveaux formulaires que je vais transmettre. Enfin, j'en ai apporté aujourd'hui un certain nombre que je vais transmettre. Voilà. Mais pour le reste, il y a un potentiel de victimes très important, mais je ne peux pas aujourd'hui vous dire exactement le nombre pour toutes ces victimes qui sont le long de la frontière. Bien entendu, je m'associe à la demande de mon confrère Paulina Massida sur le fait d'avoir la possibilité de continuer à déposer les formulaires tout le long de la procédure.
Thank you, Ms. Rabe-Sandatana. And from registry, any submissions?
Mr. President, if I may.
Yeah.
Merci, Monsieur le Président. Juste aussi une mise à jour concernant les anciens enfants soldats. Comme vous le savez, le chef d'accusation 29 concernant l'enrôlement d'enfants soldats de moins de 15 ans et de leur utilisation active à des hostilités a été confirmé au regard de M. Yekatom, mais non pas au regard de M. Ngaissona, ce qui fait que le nombre d'anciens enfants soldats qui ont participé au stade préliminaire doit rester le même. C'est donc 88 anciens enfants soldats. Concernant les nouvelles demandes de participation, notre équipe n'a pas procédé à la collection de telles demandes, puisque c'est la responsabilité primaire de nos collègues de la VPRS. Un certain nombre de personnes se prétendant anciens enfants soldats des anti-Balaka nous ont contactés. Nous avons envoyé ces informations à la VPRS pour le traitement. Je vous remercie.
Thank you very much. So I was a little bit premature, so then any submissions by the registry?
Thank you very much, Mr. President. I will start with the update on the applications received and the review where we are. To date, the registry has received a total of 1,339 applications from victims in the proceedings in relation to this case. This figure includes the 1,244 applications that we mentioned in our last filing that were received during the pre-trial proceedings, and 95 new applications that we have received lately, including the 74 that Mrs. Paulina Macida has just mentioned. The registry is still carrying out its comprehensive review of the applications received during the pre-trial proceedings in light of the confirmed scope of the case, as we already reported in our last filing 470 of the 8th of April. The registry is also currently in the process of going to the common legal representatives to consult them on the 1,087 participating victims regarding the result of our ongoing review. In particular, in relation to those participating victims which might be negatively impacted by the decision on the confirmation of charges. In order to finalize our legal analysis on these applications, the registry is waiting for feedback and supplementary information to be received from the common legal representatives. We are at the moment receiving already some feedback and supplementary information, but we are still waiting for more. The registry will also shortly come to the chamber to seek for guidance in relation to some issues that we need clarification on, that are issues that come from the clarity of the decision on the confirmation of charges on some aspects of the scope of the case. Now, turning to the forecast on potential new applications that we will receive. As everybody already mentioned, there are COVID-19 restrictions, and due to these restrictions, the registry has not been in a position to conduct yet face-to-face interviews with victims, nor to ask our trained intermediaries to assist in this task. The registry, however, has been informed that approximately 300 individuals have already expressed their interest in filling in participation forms in relation to this case, but no application has yet been received in relation to these 300 individuals. The registry is also exploring ways, options to bridge the COVID-19 related physical restrictions. And for example, we are currently exploring whether we could collect forms through telephone meetings or through other virtual tools or forums to communicate, while of course observing the the security and safety restrictions. We are also exploring whether we could do so through information dissemination through our intermediaries that have been selected, also observing health security rules. The registry anticipates that there will be delays in accessing to relevant victims, as some of us have already highlighted. And we anticipate that this might necessitate the continuation of activities in relation to victim participation through 2021. This is why the registry concurs with the proposals made by the common legal representatives and suggests that the Chamber might opt for the option of having a no cut-off date until the end of the prosecution case if there should be a cut-off date. Otherwise, our preferred option is there would be no cut-off date, and we would be able to carry on collecting applications from victims and transmitting them in batches on a rolling basis. And if the Chamber is willing to consider these suggestions, the registry is in a position to be ready at short notice to make written submissions on these suggestions. Thank you very much.
Thank you very much for your concise information. I don't think that the defense would want to comment on that, or do you? Mr. Knopf, shortly,
Yes,
please.
very, very brief, Mr. President.
Keep the time in mind.
Yes. With respect to the cut-off date, I think that's relevant. I assume that, at least I hope that the figure, the year 2021, will not influence the minds of the judges when it concerns the start of the trial, because...
No, definitely not.
Thank you. Our submission is, on the 5th March 2019, the pretrial chamber made its ruling on victims' participation. It was advertised on the ICC website, meaning that since 5 March 2019, victims could supply their applications. In our submission, there should be a cut-off date, and I think it's for us not acceptable that even until the end of the prosecution case, victims can apply their applications, can apply for applications. So we insist that the chamber should, in light of the time frame of since 5 March 2019, set either the trial date as a cut-off date or, like in the Ivorian case, 90 days before the trial starts, as a final date for victims' applications.
Thank you very much.
Thank you.
Ms. Dimitri, any comments on that?
No, Mr. President, I have 2 more points, but not on this. Thank you, Mr. President. I'm in your hands because I look at the time. I can be quite short, but 2 matters arise since the submissions on the first status conference. I stand ready to file a written motion, but written submissions, but I can deal with them I believe, in less than 10 minutes.
Let us short finish this topic,
Yes.
and then I give you the floor.
Thank you.
Again. Whichever system we adopt, if a cutoff date or not a cutoff date, and when a cutoff date, at what time, the Chamber urges VPRS, but this is taken to immediately commence the collection of further victims' applications, and of course to be in constant conversation and communication with legal representatives of the victims. The Chamber also notes that the modalities of victims' participation during the proceedings and their presentation of evidence will be part of an upcoming Rule 140 decision that is relatively clear. And now I give the floor again to Ms. Dimitri, but could you shortly flag what it is about, and then we can decide if we prefer to have written submissions or if you can present it orally.
Yes, Mr. President. So, and I can assure you that they were raised with the prosecution in inter-party communications as well as in meetings, but we didn't find a resolution, which is why we need the intervention of the Chamber. But as I said, I'm in your hands if you want written submissions. The first point is in relation to disclosure of screening notes. We understand your decision on draft statements. I'm not coming back on that, but we have an issue in relation to screening notes.
Then submissions, please.
Okay.
Yeah.
So, thank you, Mr. President. The first since the insurance of your decision on draft statements, there's been a disagreement with the prosecution in relation to screening notes, and they're on notice this morning that I wanted to address this. So on the 3rd of September 2019, the pretrial chamber, as you know, issued a decision on the defense motion for extension of time to file its list of evidence, filing 315. And in that decision, the order was for the prosecution to disclose the 108 screening notes for witnesses upon whom the prosecutor will rely at the confirmation hearing.
Mr. Mitre, that was my mistake. I wanted written submissions. I said submissions, but that was simply my mistake. So I have to take this upon me. So this is very specific, and we have to think about it carefully. We can't say something meaningful on the spot here to it. Yeah.
Okay.
So we will really appreciate it if you
No problem.
make written submissions.
Can I just inform the chamber about my second point, and you can discuss?
Of course.
Okay.
Yeah.
So the second issue, it's just to supplement our submissions in relation to the amendment that we proposed for the redaction protocol. You have our submissions. I'm not going to repeat them. I simply want to flag that it's a recurrent problem. We received in the latest disclosure batch, I can give concrete examples for the chamber. In the latest disclosure batches of witnesses, we continue to receive statements with B1, B2, or B3 redactions on individuals who are direct witnesses of alleged incident that that our client is charged with. I have, for example, in package increment 34, 35, and 36, I have a B3 redaction over a name of an alleged victim of Mr. Yekatom's element. I have the ERN numbers if your honors wish to look at them. I also have...
You are now on number 3 on the list to speak too quickly. I have been reprimanded. But we can also shorten this one. This is also very specific. We have to look into it specifically. So please, we know what it's about. You have flagged it. That's okay during the status conference. But please make written submissions on that.
You want written submissions?
Yes, please.
Okay.
Please. Thank you very much. Because we have one final item that was not on the agenda, but it appeared to be to mention it would be necessary to mention it. That is the scope of the charges. Before we close this hearing, therefore, the chamber wants to note let me word it this way, the concerning number of motions relating to the scope of the charges as set out in the confirmation decision. In this regard, the chamber particularly notes the prosecution's Regulation 55 request, which has already been adjudicated, the pending motions by the Yekatom defense to dismiss a mode of liability and responses thereto, the motion for additional details and responses thereto, as well as in the Ngaisona's defense's observations on the preliminary list of witnesses, which is connected to that. The chamber recalls its findings in decision 542, namely that, and I quote here, the court's statutory framework does not provide for the possibility of a review of confirmation decisions by trial chambers and has afforded distinct powers to the pretrial chambers to determine the factual scope of the charges. Quote end. The chamber will therefore defer to the PTC2's findings. Nonetheless, insofar as there are uncertainties, mere uncertainties, as to the interpretation of the confirmation decision, the chamber wants these matters to be settled as soon as possible, and certainly before trial starts, and does not want to be followed by this as a recurring theme throughout the whole trial. If it is of the utmost importance that the accused fully understands the scope of the charges and that all parties and participants can properly prepare for trial. It is therefore in the interest of everyone to resolve any uncertainties about the charges at this juncture, as far as it is possible to do so for this chamber. Consequently, the chamber sets 31st August 2020 as the final deadline to raise any remaining issues in relation to the charges. Thereafter, the chamber will not hear any more motions on this matter. This was the last issue the chamber wanted to address today. And Then I would like to say for clarity at the end that we have to put on record that Mr. Ngaissona, I think it was clear, but to put it on the record, was provided with the possibility to attend this status conference via video link, but chose not to do so, whatever the reason for this may be. This is not a reprimand, this is simply to make it clear for the record. The Chamber would like to thank the parties, the participants and the registry for the helpful submissions today, as well as the interpreters. That we were so fast had of course also something to do not only with the personal features, but also with the fact that we have a limited time. So in the end, for example, I forced a little bit Ms. Dimitri, and she went faster than she would perhaps normally do. So bear with us, please. We thank the court reporters, security officers, and the court is adjourned.
All rise, veuillez vous lever.